Good afternoon. Attorney Protective would like to welcome you to today's webinar, Wrapping Up Loose Ends, Ethical Considerations for Stepping Away from Your Practice. Please reference your materials for information about today's speakers, Erin McCartney and Kate Gould. With that, I would like to introduce your first speaker, Erin.
Great. Thanks so much, Michelle. Well, for many attorneys, especially a solo attorney, the thought of stepping away from your practice for a week or more to take a vacation can be daunting. So instead of creating a healthy work-life balance or proactively trying to avoid burnout, the vacation often seems to increase the stress and the pressure that an attorney faces. So as a result, it often feels easier not to take a vacation. But it doesn't have to be this way. So with some advanced planning, it is possible to take and actually enjoy a proper vacation. And Kate and I are hopefully going to give you some helpful tips. Today, we're going to talk about attorney burnout and law firm employment trends and statistics. We're also going to talk about taking a vacation as far as tips for maximizing your time out of the office. We'll also cover succession planning and considerations when identifying a surrogate, as well as retirement and what needs to be done, and then on the other side, thoughts about buying a law practice from a retiring lawyer. And then we'll end the presentation today with closing your practice and also looking at some insurance considerations to closing your practice. So with that, I'm going to hand it over to Kate to talk about the first thing, attorney burnout and law firm employment trends. Kate?
Great. Thanks so much, Erin. I know I don't have to explain what attorney burnout is. We have all experienced it. Although our jobs can be incredibly fulfilling, being a lawyer is, by nature, stressful and exhausting. From client demands to excessive hours, many overworked lawyers experience burnout and even mental health struggles. The World Health Organization has identified several signs of burnout, including feelings of exhaustion, pulling away mentally from a job, and work-related cynicism. For some of our colleagues, burnout has unfortunately led to substance abuse, depression, and suicide. As shown on the slide, a Bloomberg Law survey shows varying degrees of burnout among attorneys, of course peaking at the end of the year in quarter 4, but always present and actually hovering around 50%. Female attorneys show a higher rate of burnout than their male counterparts, and caregivers, whether caring for children or aging parents, are statistically more burnout than those who do not have those responsibilities. These figures are probably no surprise to the many working parents and lawyers with important family responsibilities outside of the office. As lawyers, we are high-achieving individuals who are innately competitive. Qualities like these make us great lawyers, but can also lead to burnout, especially with the many responsibilities and obligations we have besides our jobs. So how do we identify burnout and try to avoid or remedy it? Take a moment to assess your situation. Are you constantly tired even when getting enough sleep? Are you feeling detached from work and having trouble concentrating once you're there? If you find yourself self-medicating and in a chronic state of stress, you may be closer to burning out than you think. Firms are recognizing this and have tried to accommodate their lawyers. Hybrid work schedules are even more commonplace now post-COVID, and some lawyers work on a part-time basis. Still, a recent 2022 Legal Trends report found that even with certain accommodations, 86% of lawyers work outside of the typical 8 to 5 workday, and 73% work outside of regular business days. Seemingly, our now remote capabilities have resulted in some of us working even more. The ABA highlighted a New Jersey 2022 survey which showed that 28% of its state's lawyers have considered leaving the profession due to burnout or stress. Quite frankly, the work we do is hard and demanding, and these statistics highlight the need to take a break. Erin is going to discuss the importance of vacation and taking that break, along with the certain ethical guidelines to keep in mind. But if you don't have a trip on the horizon, remember that you can try to avoid burnout by getting enough sleep, exercising, getting outside when you can, cultivating hobbies outside of work, and setting boundaries to ensure you can be your best self and the best lawyer for your clients. Erin?
Great. Thanks, Kate. So Kate talked about burnout. That is definitely a real thing. So while we cannot shirk our professional responsibilities, we can and we should periodically step away. Now, your duty as an attorney, it requires competence, diligence, and proper client communication. And these duties that are at risk of compromise anytime you disengage from your practice. However, with proper planning, these risks can be avoided. So I'm going to quickly cover the applicable ethics rules and then provide some realistic and hopefully helpful tips for those who are getting the itch to go somewhere warm. Since I'm in Philadelphia and I know it's starting to get cold here, I'm definitely starting to think about planning a vacation. So with that, let's first look at Rule 1.1. This is the rule regarding competency. So whether away on vacation or recovering from a surgery, lawyers remain accountable to their clients to provide competent representation during any absence. So although you may be enjoying a Mai Tai on the beach, you are still accountable for the legal services for which you are engaged, and you must perform these services competently. Unfortunately, despite adequate planning, some emergencies cannot be anticipated. Therefore, as the best practice tip on your slide states, while unplugging, it may be necessary to maintain some level of contact with your office to ensure this duty is fulfilled. We will get into this a little bit more when we address tips for maximizing your time out of the office. But next, we're going to quickly look at the rule regarding diligence. So Rule 1.3 of the model rule states that a lawyer shall act with reasonable diligence and promptness in representing a client. Just like the requirement to be competent, a lawyer's duty to remain diligent in the representation is not somehow suspended during vacation or even a short-term absence from the office. In the litigation world in particular, calls or inquiries from the court should be promptly addressed by you or another attorney in your absence who's familiar with the case. Diligence means staying organized in order to meet all deadlines. In other words, not dropping the ball on any client needs. Being on vacation is not an excuse. You cannot simply check out and ignore any deadlines during this time. So finally, under Rule 1.4 of the model rules, lawyers are required to keep the lines of communication with their clients open at all times. They must keep their clients reasonably informed about the status of their case and comply with reasonable requests for information. Just like the other ethics rules, an attorney's duty to communicate does not cease to exist because you're on a vacation. As an attorney, you are still required to keep a client reasonably informed about significant developments relating to the representation. So failure to communicate with and inattention to the needs of a client may constitute grounds for discipline. Honestly, we've all had experience with some clients that can be a little bit more high maintenance than others. So they require more attention. They require more frequent communication. And much to the chagrin of some clients, you aren't on call at all times to answer their burning legal questions. Now, the reason I keep emphasizing the word reasonable is because the standard here is reasonableness. So that being said, by providing a timeline for when your clients can expect to hear from you or someone in your office, you can satisfy this reasonableness standard. But ethically, you cannot cut off all means of communication with them. This is why setting boundaries and tempering client expectations for a vacation from the office is so important. You absolutely can enjoy your time away while fulfilling your professional responsibilities, but you may need to do a little pre-vacation planning and strategizing. So let's look at some best practice tips for maximizing your time out of the office. So although completely unplugging may not be possible, there are some pre-vacation strategies that you can implement so you can return to the office feeling renewed and relaxed and refreshed. You want to notify clients. By letting your clients know that you'll be away, you will likely avoid an interruption on your trip. Chances are your client will appreciate the fact that you gave them advance notice and hopefully respect that boundary. We just discussed Rule 1.4 and how lawyers need to communicate with their clients promptly. So ensuring clients are still getting timely updates on their cases, if not from you, then from a staff member or a colleague, this is going to be key. You can always suggest that they contact your assistant who can help determine whether something is actually an emergency or if you can address the matter when you return. It's really going to be up to you how much you want to stay connected, if at all, but you'll probably want to include something about your availability when you notify them. You want to set expectations. Of course, you'll also need to tell your staff, your firm partners, and anyone else you work with that you'll be taking a vacation. You want to give clear instructions for the work that needs to be completed in your absence, contact information for the lawyer providing coverage in your absence, and we're going to talk about vacation buddies in just a minute, so we'll expand upon that. But you also want to think about how to contact you on your vacation and when it is and isn't appropriate to do so. Clients may think something's an emergency when it's not. So you want to make sure your assistant or the attorney covering for you can determine the difference. My advice is tell everyone you're going on vacation. As soon as you settle on the dates, start giving notice as soon as possible to courts, coworkers, other counsel, as well as the clients to avoid any potential scheduling conflicts. Even if your trip's months away, you'd rather err on the side of more notice than not enough, although you'll probably also want to remind them of your absence as the date gets a little bit closer. Next, coordinate with your legal staff and fellow attorneys. Ask that your legal assistant be in the office when you're away. By having someone familiar with your cases in the office, you and your clients will have greater peace of mind that nothing will slip through the cracks while you're gone. You can also ask that your assistant run any questions by an attorney in the office by coordinating with that attorney before you leave. And then review your bills. If your billing cycle falls around your vacation, make sure you review your bills ahead of time so they are mailed in accordance with your usual monthly schedule. Your client's likely expecting a bill, and if you ever take our billing webinar, you'll hear me say over and over again that consistent billing procedures could be the difference between getting paid and not getting paid. Plus, it's one less thing you'll need to add to your to-do list when you do return from vacation. You also want to calendar some breathing room. So be sure to timely mark out your vacation time on your calendar so nothing is scheduled on your anticipated days out of the office. Also think about what will happen immediately before and after you return. If at all possible, set aside some time to plow through work and tie up loose ends before you leave. This includes both finishing up outstanding tasks and providing information to others so that they can complete work for you. The more organized your caseload is, the more fully you'll be able to enjoy your vacation. And then in terms of your return, avoid setting deadlines for the first 2 or 3 days that you're back in the office. You'll likely want to be catching up and reviewing what you've missed during this time, not rushing to meet a deadline immediately after returning from time off. Also, it may be hard to relax on your vacation knowing there is a hearing or a client meeting scheduled on the day you return to the office. So upon your return, think about reserving a day to catch up on email and voicemails. And then think about, too, with flights these days, you never know if you're going to get delayed or canceled. So you don't want that added stress either. And then set your away messages. Record a voicemail message advising of the dates that you will be out of the office and who can be contacted for immediate assistance. Likewise, setting an automatic email reply with the same information and instructions is an easy way to set expectations as to when your clients will hear from you upon return from your vacation. I know if I'm going to be on vacation, I usually write that I have no access or very limited access to email because I want to set the expectation that I'm not going to be checking email, but here's the person you can contact if you need an immediate answer. So something else to think about. And then it might seem obvious, but a correctly worded out-of-the-office message can save you a number of stresses, namely from missed requests on urgent matters. This can also help maintain a client's faith in your ability to handle their case, cementing your reputation as a reliable lawyer. So craft a message that is relevant, informative, and polite, but also word it in a way that makes it clear that you're only available to respond to serious emergencies. And then always include an alternative contact for urgent matters. And then short-term coverage. As a solo practitioner, you may have had reciprocal arrangements with a colleague to cover each other's practices when you were out of town. So be sure to brief them on anything you anticipate might come up and let them know under what circumstances to reach you when you are gone. And I can't stress enough that one of the keys to peace of mind on a vacation is utilizing a vacation buddy. In choosing a vacation buddy, there are several things to consider. One important factor that should go without saying is that your vacation buddy should be someone you know well enough to determine his or her trustworthiness and accountability. If you think you're going to spend your vacation worrying about whether this particular potential vacation buddy is staying on top of things, that's probably not the best person for you to pick. Equally important is to find a vacation buddy in your practice area, and then once you've selected a potential vacation buddy, be sure to be clear about what you are needing them to do. Are they checking your case online dockets? Are they checking your email and scanning and emailing you anything that's urgent? Once your targeted vacation buddy has agreed to fulfill this role, decide how formal you both want this relationship to be, whether you want to put this arrangement in writing or not. If you really only need your vacation buddy to check online dockets for your cases, informal is probably fine. But if they're doing more than that, you might want to think about putting this arrangement in writing. And then I would also recommend mapping and strategizing your current cases. And what I mean by that is that it's beneficial to map out the potential timelines for your open cases and then create a case flow that's favorable to your vacation time frame. For example, you may have an opening brief that's due a couple of days into your vacation. Based on your current workload, you may be in a position to file it a few weeks before you leave. So think about that as well. While you will undoubtedly end up with a couple of late nights before a vacation, implementing these tips and strategies, it can give you peace of mind while enjoying your time off. I think with most things, striking that balance between going completely off the grid and being available, it's going to depend on the lawyer and their practice and how comfortable they are going off the grid. So think about what works best for you. And then that being said, it is possible to take time to relax and recharge while adhering to these ethical obligations that we just talked about. I'm going to now pass the mic to Kate to talk about succession planning. Kate?
Great. Thanks, Erin. We're now going to switch gears a bit, and we want to dive into succession planning and the need to have a plan. Although none of us want to think about our death or potential incapacity, it is our professional responsibility to put some procedures or people in place to step in if necessary. For some practitioners, this may be a surrogate attorney. You'll see Rule 1.3 on your screen, which contemplates the designation of a surrogate attorney. Now, what is a surrogate attorney? A surrogate attorney is a successor attorney designated to take action to preserve and handle the law practice of the now deceased or incapacitated attorney. As states continue to develop their own rules with respect to surrogate counsel and succession planning, the ABA provides some helpful guidance. Comment 5 to ABA Model Rule of Professional Conduct 1.3 states that the duty of diligence may require a sole practitioner to designate another attorney to review client files, notify clients, and determine the need for immediate protective action in the event of the death or disability of the sole practitioner. Practically speaking, the surrogate attorney should be someone who is familiar with your practice areas and that can competently step in and take over your cases for the short term, if not actually retained by your clients. The attorney should have the capacity and time to effectively run your practice or assist in winding it down. Oftentimes, this can be a reciprocal arrangement between practitioners. You'll want to consider their age and how long they expect to practice to hopefully give your clients the continuity in representation they deserve. Having someone ready to take the reins for years to come not only gives your clients peace of mind, it is often cost-effective for them. To the extent you can, you'll also want to check for any conflicts. As you can imagine, states have different rules for succession planning. While designating a surrogate attorney is not yet required in every state, several jurisdictions mandate some form of succession planning. If we do not review your state's rules here, be sure to check your jurisdiction to ensure compliance. But I want to give a brief overview of some states' rules to give you a flavor for what is being required across the country. As we look at the state laws, I'm proud to say as an Indiana barred attorney that the ABA identified Indiana's rule as the gold standard for attorney surrogate rules. The rule provides at the time of completing annual registration, a lawyer may designate a surrogate attorney by specifying the attorney number of the surrogate and certifying that the surrogate has agreed to the designation in a writing in possession of both the lawyer and the surrogate. In Indiana, when the lawyer dies or becomes incapacitated, a verified petition is filed with the Supreme Court and served upon the designated attorney surrogate. The court may then appoint the attorney surrogate to continue the deceased or incapacitated lawyer's practice. Indiana's rule is quite comprehensive to the point of actually itemizing certain actions the surrogate attorney may take upon appointment, including taking possession of the files and records of the practice, applying for extensions of time, and notifying clients for purposes of the clients collecting their files and hiring replacement counsel. The rule further provides that the court granting the petition for appointment of surrogate counsel has jurisdiction over the closed files of the attorney and may issue orders with respect to the files, including for destruction, alleviating the potential headache of the surrogate attorney and perhaps the lawyer's heirs as they wind down the practice. The rule further provides that certain deadlines and statutes of limitations are actually automatically extended for 120 days from the date of filing the petition. The next state on our map is Florida. Florida is one of the states that mandates designation of a surrogate attorney. So through the state bar registration process, Florida attorneys designate an inventory attorney to take over if an attorney dies or becomes incapacitated. The rule provides that the inventory attorney shall inventory the files of the subject attorney and take such action as seems indicated to protect the interests of the clients. Next, South Carolina. South Carolina Rule of Professional Conduct 1.19a requires its attorneys to prepare detailed succession plans specifying what steps must be taken in the event of their death or disability from practicing law. The rule contemplates designation of a successor lawyer and even provides that the designation plan may be set out in a fee-sharing arrangement for the successor attorney. Next, looking at Illinois. Illinois requires active practicing attorneys to state in their annual registration whether their organization has a written succession plan. However, the rule, interestingly, does not require that a plan exist. In New York, they have a rule of professional conduct regarding diligence, which mirrors the ABA rule, stating that to avoid possible prejudice to client interests, a sole practitioner is well advised to prepare a plan that designates another competent lawyer to review client files, notify each client of the lawyer's death or disability, and determine whether there is a need for immediate protective action. While designation of a successor attorney is not required, it's certainly recommended. Looking at Texas, the Texas State Bar urges its attorneys to develop succession plans and even designate a custodian attorney in advance. Texas practitioners can use the State Bar portal to designate their custodian attorney. The custodian attorney does not inherit the lawyer's law practice, but it is anticipated they will serve in a more limited role to wind down the practice. Texas likewise provides that upon notice of the unexpected death of a busy solo practitioner and the absence of any succession plan, that the Office of Chief Disciplinary Counsel or other interested person may petition the court to assume jurisdiction of the lawyer's practice. Pursuant to the rules, the court will appoint a Texas attorney to serve as a custodian attorney. And finally, California. I left it off the map here, but I did want to highlight it. The California State Bar has an attorney surrogacy program which provides a model agreement for the designation of an attorney to step in if a lawyer dies or is incapacitated. In fact, it provides a sample agreement which details the responsibilities of lawyers involved, titled Agreement to Close Law Practice in the Future. And this is done for purposes of compliance with the California Business and Professions Code Section 6185 and the Probate Code. Now, in reviewing just a few states' rules concerning successor attorneys and succession planning, you can see how different states have addressed the issue. Again, in the busy day-to-day work of a law firm, succession planning may not be top of mind, but it's certainly something to start thinking about. But if you haven't, you aren't alone. According to a 2018 Thomson Reuters survey of U.S. mid-sized law firms, The industry is lagging far behind in terms of leadership and firm succession preparedness. In fact, only 40% of firms surveyed said they felt prepared to deal with the retirement and succession of partners, while 61% said they were concerned about their lack of preparedness. In addition, only 37% of surveyed firms said they had a formal succession planning process in place or were in the process of creating one. The remaining 43% had an informal process or didn't even have succession planning on their radar. Ida Abbott, president of Ida Abbott Consulting and a fellow with the American Bar Foundation, says, the succession planning issue is becoming really urgent because we know about a third of equity partners are at retirement age. You're looking at the potential for a major outflux. Even firms with mandatory retirement run into a lot of problems because lawyers tend to not believe it's actually going to happen to them, and then delay thinking about it or doing anything about it until the issue is right in front of them. So, again, just looking at these statistics, if you don't have a plan yet, you aren't the only one. I'd encourage you to start with the ABA materials on succession planning. You'll find great state-specific resources as well as their recommendations for comprehensive succession plan, which should include, at a minimum, written instructions concerning how and where client information is stored, including bank and other account details such as operating and trust account information. Information concerning disposition of closed client files, as well as information about law office equipment leases or other contracts, information regarding payment of current liabilities, instructions to gain access to computer and voicemail passwords, and finally, information detailing how the successor will be compensated. Now, if you do have a surrogate attorney and you have identified one, let's turn to some practical ways to set up your surrogate for success. Quite simply, efficiently running your practice is the best way to prepare your surrogate attorney in the event they will need to step in. Regardless of the size of your practice, implementing and documenting consistent office procedures and protocols is paramount. By developing a manual or simple training materials that clearly communicate how to use the firm's calendaring system, the conflicts check procedure, and accounting systems or billing software, the surrogate attorney should be able to seamlessly transition into your practice. Perhaps the most important means to ensure a smooth transition is maintaining an active file list and calendar. The surrogate attorney's first order of business will likely be reviewing your file list and cross-checking it against the calendar to ensure no court dates or deadlines are missed. Assistants and paralegals may assist with keeping you organized on a day-to-day basis, but they should also be well-equipped to assist the surrogate attorney. Quite frankly, your practice, and maybe even your estate, is at risk if your files are poorly documented or incomplete. Make sure to develop and implement best practices in terms of organization now for yourself and your designated surrogate attorney. With respect to communication, the fee agreement is an effective means to advise clients who they may make contact in the event of your death or incapacity. Consider adding a provision to your fee agreement with the surrogate attorney's name and contact information. Most clients will appreciate the proactive steps you have taken in protecting their interests should you be unable to continue to represent them. We're now going to look at some retirement considerations. Erin?
Great. Thanks so much, Kate. Great tips there. So as Kate said, let's look a little bit at retirement. And why is closing down a law practice any different than closing down any other business? As a lawyer, we have more ethical considerations than other professions. So that's why. So let's look at what needs to be done. I have some resources here on the slide, which you can see, and I do recommend that if you are thinking about retiring or planning to retire, to contact your local bar for additional resources. You'll see I have here the Florida Bar. It has a great checklist for lawyer retirement. So I have the link here. the California State Bar, they have a website that actually contains a section called Senior Lawyers Resources. That's another great resource. New York also has similar resources. So I recommend contacting your local bar for additional resources. And then as far as practical tips, what needs to be done? The first thing you need to do is stop accepting new cases. Even before you begin the process of winding down your law firm, stop accepting new cases. Each new client you consult could become a potential conflict when you do close your law firm. So speak to other attorneys about referrals. Referring cases out could garner some income even as you begin thinking about closing your law firm. And then set a date. Closing a law practice does not happen overnight. It will likely require action over several months. So pick a date based on your active case files and their already scheduled deadlines and your ability to secure permission to withdraw while trying your best to set the client up for a successful transition. This is much easier said than done. So I recommend mapping out a retirement timeline. This will give you an idea of what your rough time frame for retiring might be. Start by compiling a detailed list of all of your open cases. And then next, estimate a timeline for finishing the work on each case. You may want to do a range for each case. Try to figure out the timing and what that would look like if the case moved at the average rate of your other similar cases, as well as figure out the timing if it moves more slowly than is typical. Once you've done this for all of your open cases, you'll have an idea of when approximately you would be in a position to retire. You may find that your first opportunity to retire is sooner than you expected or wanted. Another possible outcome of mapping your timeline to retirement is that you find out it's a little bit further out than you had hoped. So mapping out a timeline is another great step to take. And then, of course, once you've set this date, it's time to start informing clients that you are closing your legal practice. Contact your long-term clients, discuss any pending cases and their options such as new counsel, attorney's fees due, or refund of fees if you are not going to be able to complete the work when the payment's already been received. From a risk management perspective, it's important to document all proper communication to clients advising that your firm is closing, because being able to produce clear documentation about when and how you told clients about your law firm closure, it will help if clients fail to take those steps to protect their own interests. Attorney closure letters, they should be used to convey the proper steps clients should take surrounding the law firm's impending closure. I recommend looking at sample dissolution letters and then tailor them to your own needs. These can be found on your state or local bar association's websites. You'll see on the next slide that there's one that I pulled from the South Carolina bar, but there's a lot of good examples out there of dissolution letters. So I would suggest looking at those and then, of course, tailor it to your own needs. But at a minimum, your letter should inform the client of your legal practice's closure date, the status of your client's case with you, and how you'll handle the transfer of your client's files. If you hold funds in a trust for a client, your law firm closing letter should also discuss the amounts and how refunds will be handled. And then look at the status of client cases. Each open file needs to be considered with regard to its deadlines and its fee arrangements. Remember, if the file is being either given to the client or the client's new attorney, to stress in writing that time is of the essence. In cases where the client is obtaining new counsel, be certain a substitution of attorneys filed. Once clients are informed, start packaging their files for transmission. You should have two goals when packaging the files. One, make it easy for the client or the future lawyer to continue pursuing their interests. And then two, be sure to remove any document of value from the archives. And Kate's going to talk about this in just a bit, so I'm not going to steal her thunder here. But be sure and retain a copy of the file and a written acknowledgement from the client or new attorney that the file has been transferred. After obtaining the client's consent, file a motion and order to withdraw from any pending litigation. Next, return closed files and original documents. A retiring attorney is likely to have boxes and boxes of closed files. Kate and I get asked a lot on our risk management hotline, how long do I need to keep closed case files? Different states have different requirements, and this is something else Kate's going to cover in just a bit. So I'm going to move on to terminate leases and rental agreements. We talked earlier about the benefits of mapping out a timeline to retirement for you and organizing your caseload. But mapping out a timeline also helps provide a time frame to manage the renewal of practice-related contracts, such as office space leases, Westlaw, LexisNexis contracts, telephone contracts, domain name rentals, website hosting, all of this kind of stuff. These renewal dates should be added to your timeline because you will need to reach out to your landlord and vendors to finalize arrangements. You're going to need to terminate your lease for your office space. You'll also need to terminate equipment leases and make arrangements for the removal of those items. For any contract that will extend beyond the close of your practice, you may need to negotiate early termination or see if you can switch to month-to-month at the final renewal dates. Also be aware of practice-related contracts that are tied to your credit card and renew automatically. The utilities and services need to be canceled. You need to cancel your office subscriptions and other memberships. There's a lot to do here. So you may decide to extend some of those contracts, such as those for business email or websites or your telephone, so that you can provide notice of your retirement, as well as how to contact you regarding a closed case. So consider letting these outgoing messages run for several months after you close your practice. And if you have a website, you should consider reducing it to one page, which is enough to inform those visiting your site of your retirement and their options. And then you want to close your trust accounts and notify bar associations and professional organizations of your change in status. Part of submitting your notice for retirement, it includes updating your status in the attorney information system. You can change your status from active to retired, but if you think that you may practice again in the future, you should change your status to inactive. If you select a retired status, you will not be charged any bar fees, whereas inactive status, it will require you to pay your bar fees to maintain your license. So both the retired and inactive statuses, they can be changed back to active if you meet the requirements set by your state bar, but inactive is typically a lot easier to change. So keep that in mind. And rulings on this procedure are going to differ from state to state. For example, in California, I know the annual license fees are waived for licenses on inactive status for attorneys who are 70 years of age. So in California, there's not retired status options. There's only voluntary statuses such as active, inactive, or resigned. They advise that resignation should be considered a permanent step for attorneys who are certain they would not wish to practice law in California again. So readmission after resignation would require a reinstatement petition in the state bar court, which usually entails retaking most of the bar exam, which I'm sure no one wants to do again. So again, the most important thing is check in with your local bar association and then also notify any insurance carriers about your retirement. The risk covered by malpractice insurance does not just go away because your law firm is closed. Discovery periods, limitation for malpractice claims will continue after law firm closure. So a lawyer leaving the legal profession, they should contact their insurer to discuss continuing coverage even after the closure of the law firm or the addition of ERE to the policy prior to closing the law firm. And for those of you who do not know what ERE is, we're going to get to that in just a bit too when we talk about insurance considerations. But to finish notifying the insurance carriers and wrap up this section of retirement, just think that walking away from a law practice, it's not as easy as turning off the lights and locking the door. It does take a bit of planning, and the more organized your office is, the simpler those steps are going to be. So if you already have a procedure to produce a list of client names and contact information for all open files, an up-to-date calendaring system, which Kate talked about, and all deadlines and follow-up dates, current billing records, and all of that, then locking the office door is going to be a lot smoother and quicker for you. On the next slide, you're going to see what I referenced here. This is just a sample letter notifying the client of retirement. Again, I would look at your local bar and see if they have any of these templates for you, but this is one from the South Carolina bar that I really like. And so then next, We also want to talk about quickly buying a law practice from a retired lawyer. We wanted this webinar to also help lawyers who are thinking about retirement, but also to help lawyers that are thinking about growing their practices still. So whether you've started a law practice and you're looking to expand, or you're thinking about leaving a large firm and venturing on your own, buying a law practice might be right for you. Regardless of where you are in your career, it can be much easier and actually more cost-effective to buy a law practice than to start one on your own. So many attorneys, they don't even realize or they don't even consider purchasing a law practice because they don't realize they can, or they don't know where to start with the process. However, buying a law practice is both possible, and it's a great avenue to pursue for a savvy business person. So I'm going to talk about a few things to consider if you are thinking about starting your own practice by purchasing a practice. So where to find law practices for sale? Unlike real estate, you're not going to find a for sale sign outside of a law firm, even when the owner of the firm wants to sell their practice. So how do you find a firm that you can purchase? Well, an organic path is to network with older attorneys who may be looking toward transition. You can also look at registries created for this niche. There's one called Private Practice Transitions. There's another one I know of called Biz by Sell. Some registries even provide support by making experts available to answer any questions that you might have. And you can also reach out to your state bar association. State bar associations are valuable resources that can guide and support lawyers when choosing which firm to buy and how much to pay for it. For example, I know the Washington State Bar offers a career center that you can filter to show practice transition. And then with this filter, you can find attorneys who are potentially retiring or looking for buyers. So another thing, reach out to your state bar association for more resources. But you should also consider the area of practice, the client base, and branding if you're contemplating this. Of course, you don't want to buy a commercial law firm if your area of practice is personal injury. So to ensure that you target the firms that most align with your experience and your goals, you need to first consider your long-term goals, what type of attorney you want to be, where you want your practice to go, and in what areas you see your practice growing. Similarly, it is important to review the existing clients of a firm for sale to gain a better understanding of the needs being met and whether those clients seem like ones with whom you would have good chemistry. Of course, you also need to do your due diligence. You should review financials, tax returns, cash flow projections, and meet with the owners and key staff. While making the decision to purchase a law firm, it's an important step. Your due diligence is going to be the most time-consuming step in this whole process. So when you're conducting your due diligence, you should engage a financial advisor, a CPA. You need a CPA to advise on the tax benefits of purchasing a law firm, and also an advisor who can help you with the deal structure. So all things that you need to think about when doing your due diligence. And then, of course, there's the ethical considerations when you buy a law practice. You're going to want to review Rule 1.17, which states that the law firm seller must make clients of the prospective firm aware of the sale and have the right to choose another counsel. Most states have similar requirements, but the rules of buying firms can vary between jurisdictions. So make sure you look into your rules before buying a practice. And then finally, you want to create a transition plan. After the sale, there's going to be a transition period. And during the transition phase, the seller should transfer the knowledge base, the key clientele, referral networks, and other elements to give you the best chance of success with your new firm. So as with any new business, there needs to be this business plan, and the business plan should include a detailed checklist of items that you'll need to work through, including production, who's going to be responsible for what work and at what level moving forward, firm management, hiring, firing, vendor management, lease negotiations, and then also everything else that the former owner was responsible for, which will now you'll be handling. So you want to think about all of these things as far as a checklist. If you're looking for more resources on buying a law firm, please reach out to me via email. I can definitely provide some more resources for this. But in the essence of time, I'm going to hand it back over to Kate to discuss closing your practice. Kate?
Thanks, Erin. We're now going to touch on some topics related to closing your practice. We'll first jump into the file retention and destruction question, look at dissolution and tax considerations, and see what the rules of professional conduct require concerning trust accounting record keeping. File retention and destruction is a difficult question for many lawyers and law firms. Like Erin said, we receive many inquiries on the AppPro Risk Management Hotline regarding file retention. Quite frankly, I think most of us would admit we have trouble letting go of old files despite rarely, if ever, referencing them. There's just something about giving the okay to shred it that gives us pause for fear of violating the rules related to file retention and destruction, or thinking we're going to need something the minute we approve the file's destruction. Of course, when closing or selling your practice, there are the practical considerations of file storage or wanting to avoid transferring an abundance of old files to another attorney. So where do you start? First, follow your policy. Understandably, for an older closed file, you may have forgotten the file retention policy agreed to in the engagement letter and hopefully reiterated in your closing letter. Consult this correspondence when you pull the file to determine whether you need to retain the file and transfer it, or if you can destroy it. If destruction would be appropriate, see if you previously agreed to provide notice and opportunity for your client to retrieve their file prior to your destruction. You can include a destruction notice in your letter about closing your practice, which may prompt your client to pick up their file, alleviating the need to further question whether you need to possibly transfer it. In the sample retirement letter that Erin spoke about, that's shown in our slides, you'll also find language concerning file retention and destruction. If you do not have a firm policy for file retention or destruction, you'll be happy to hear that the ABA model rules offer some helpful guidance concerning a lawyer's obligation to maintain client information to fulfill their ethical duties. Model Rule 1.16d provides that upon termination of representation, a lawyer shall take steps to the extent reasonably practicable to protect a client's interests, such as surrendering papers and property to which the client is entitled. While this isn't a hard and fast rule for the number of years a file must be retained, it is instructive. First, it does not require a lawyer to keep all files indefinitely. And secondly, it contemplates the possibility of returning the file to the client, while at the same time accomplishing the goal of clearing out old files. Of course, this comes into play when you're in the process of closing your firm. If nothing else, it should give you some assurance that you do not need to stack old client files in your garage, and that you can comply with the rule by reaching out to clients to pick up their file if you don't have a policy. If your client doesn't get back to you about picking up their file, you might want to run through a quick checklist before sending it to the shredder. Ask what documents are in the file. Original documents such as wills, deeds, and certain contracts should be maintained, and their destruction will likely need to be evaluated on a case-by-case basis. Some states will dictate the minimum number of years to retain the document, but you should also consider the lifespan of the document as well. For example, if the contract term is not expired, it would be premature to dispose of the document. If you are not transferring the file to the new attorney, you may want to hold on to it. Next, ask whether there's any pending litigation. And while this may not apply to all older files, I'd keep it on your checklist. If you received a litigation hold letter, you should check the status of the litigation or any government investigation before evaluating the file for destruction. Maintain the file in its entirety or transfer it, because violation of a litigation hold could have serious evidentiary consequences for your client. Also ask, what is the statute of limitation for legal malpractice in your state? Check your state statute of limitations for legal malpractice claims as the minimum length of time to retain the file. Your entire file, including all of your notes and draft documents, may be your best defense in a malpractice action. I want to briefly look at how individual states address file retention, and you'll see that it's a lot of work at the end of a long legal career to evaluate what to do with your files, and quite frankly, it has to be done on a file-by-file basis. Not surprisingly, individual states and their bar associations have different opinions when it comes to file retention. Although California courts have not yet addressed the retention period, several California bar associations have provided guidance. For example, the Los Angeles County Bar Association opines that a civil attorney should retain potentially significant papers and property in the former client's file for at least 5 years. This is consistent with the California Rule of Professional Conduct, which requires an attorney to maintain all records of client funds and other property that the client provided to the attorney for at least 5 years. In Alabama, an Alabama State Bar Association advisory opinion provides that a lawyer should maintain a copy of the client's file for a minimum of 6 years from the termination of the representation or conclusion of the matter. The opinion cautions that 6 years is the absolute minimum period, and certain circumstances may require a longer or even indefinite period of retention. Such circumstances could include files related to minors, probate matters, taxes, and transactional matters, which require lawyers to maintain a file until its contents are rendered obsolete by the passage of time and serve no useful purpose to the client or lawyer. Illinois adds another year. The general rule for file retention in Illinois is 7 years. Illinois Supreme Court Rule 769 provides that all financial records related to the attorney's practice, including bank statements, time and billing records, checks, journals, financial statements, and tax returns, among other financial documents, must be maintained in a physical or electronic file for at least 7 years. While the rule does not encompass all the potential components of a client file, most attorneys allow 7 years to pass before considering whether they must retain or if they can destroy the file. Now, while state legislatures and bar associations perhaps do not offer the bright line rules we would like concerning file retention, they do provide helpful guidance to practitioners wanting to clear their file cabinets of old client files, especially when shutting down their practice. As a rule of thumb, consider the time frames provided by your jurisdiction as the minimum length of time to keep a client file. Then exercise good judgment when considering questions of file retention or destruction. Best to err on the side of caution and keep the file physically intact or transfer it to the attorney taking over, or even maintain an electronic copy if your client doesn't retrieve it. The ABA also offers some guidance that I want to touch on quickly here, in addition to the model rule I mentioned. First, it instructs that a lawyer should not destroy or discard items that clearly or probably belong to the client unless the client provides their consent. These items could be personal file materials furnished to the lawyer, such as journals or photographs that are not available in the public record. In general, a lawyer should use care in not destroying any information the client may need which was not previously provided and for which the client may expect the lawyer to preserve. With respect to the length of time a lawyer may need to retain a file, the ABA cautions that the attorney should use discretion. In addition to complying with any state or local rules and ensuring any applicable statute of limitations has expired, the nature and contents of the files may indicate longer retention than other files. Evaluate file retention on a case-by-case basis. And if the physical file contains records of your receipt and disbursement of trust funds, maintain these records in a separate file along with an electronic copy. If your client does not want their file and you have determined it can be destroyed, be sure to protect the confidentiality of the documents when disposing of the file. Many vendors offer such shredding services. And if you return the client file or destroy it, be sure to maintain an index of those files. Again, as always, check your state rules and consult with the local bar association for specific guidance concerning file retention and destruction, especially when closing your firm, to ensure you fulfill your ethical obligations. I next want to look at law firm dissolution and the tax implications of closing your practice. So if you decided to close your practice, does this mean you dissolve it? As I alluded to in the prior section, closing your practice could also involve selling it to another attorney or firm, and Erin offered some great resources on that. So while a complete dissolution may be appropriate for some, you may have other options to explore, whether a buyout, acquisition, or merger. If dissolution is the right path to take, be sure to follow the dissolution procedure in your partnership agreement. If you're a solo practitioner, create a checklist, which might include canceling any active marketing or advertising campaigns you have in place, collecting money owed to the firm, and depending where things stand with your receivables, you may need to explore collection options with an outside firm or vendor. Be sure to settle any creditor claims, notify your landlord and insurance carrier, and consult with your client to assist with the process. You'll likely be working with them closely throughout the winding down. And finally, file the necessary dissolution paperwork with the state. Of course, of the utmost importance is properly notifying your clients, as we've discussed. The attorney-client relationship distinguishes closing a law firm from shutting down other businesses in light of the ethical obligations we must meet. We must communicate with the client, deal with client trust accounts appropriately, and remain diligent as the deadline to close the firm nears. Be mindful of the timing for your clients. You should give them reasonable notice that you are terminating the representation in light of the firm closing so they can retain other counsel and you can assist in transferring their file or returning their file and property to them. Refund any retainers or fees that have not been earned or expenses that have not yet been incurred. And keep complete records of client account funds and property for at least 5 years after ending the representation. With regard to taxes, work with your accountant to tie up all loose ends. In general, the IRS advises dissolving law firms to file an annual return for the year you dissolve your firm. If you're a partnership, you must indicate it's your final tax return. File employment and tax returns, make final federal tax deposits, be sure to issue final withholding information and wages to employees, report capital gains, losses, partner shares, W-2, and 1099 information, and of course, report corporate dissolution. I know we're running short of time, but I do want to mention the trust account record keeping rule. As you can see on your screen, Rule 1.15 addresses trust account record keeping. As I just mentioned, keeping complete records of account funds and property for 5 years after the representation ends is what is required by the rule. The slide shows the complete model rule, but as always, be sure to check your state's rule and treat that 5 years as the minimum deadline. In sum, closing a law firm takes a tremendous toll on those involved, partners, associates, staff, and accountants. The focus tends to be on the winding down of business affairs, but keep in mind the primary obligation should be to the law firm's primary asset, its clients. The lawyer-client relationship creates a fiduciary duty that does not abruptly end when the law firm decides to dissolve. That duty requires full and fair disclosure and maintenance of confidentiality until the winding down of the business is complete and all legal matters are properly concluded. I'm going to turn it over to Erin now to discuss insurance considerations.
Great. Thanks, Kate. And for those who have never had a legal malpractice claim filed against them, this is how legal malpractice insurance typically works. The professional liability policy, it provides coverage for 1 year at a time. So in order for an attorney to have coverage in place at all times, the policy must be obtained every year. So continuity of coverage is really important in a claims-made coverage. When an attorney changes firms, becomes a judge, retires, or exits private practice for any reason, an ERE becomes available and necessary. So I referenced an ERE earlier, and what that stands for is an extended reporting endorsement, and it's also known as tail coverage. So this is needed because of the claims-made nature of a lawyer's professional liability insurance policy. So the claims made policy, it provides coverage for alleged actions that occurred during the time the policy was in effect. So in other words, the coverage provided in a claims made policy, it ends when the coverage terminates. So your ERE, it's not a separate policy. Instead, the endorsement, it extends the terms and conditions of the prior existing policy, and it allows for an additional period of time for a claim to be reported to the carrier. So in other words, it allows you to report claims to your insurer after the policy has expired or been canceled. This means that no coverage will be available for a negligent act or omission which occurs during the time the ERE is in effect. And this is really important because if you're doing pro bono work for a friend after you retire, this is not covered under the endorsement. So if you think you need an ERE or you have more questions, you can contact AppPro, or if you're just looking for more information, go to our website and under Find the Right Coverage, we have great resources. One is called the Legal Malpractice 101. It clearly explains what all these terms are and what you would need when you're thinking about retirement. So in the essence of time, I'm going to hand it over to Michelle to open up our Q&A. Thanks so much, Michelle.
Thank you, Erin and Kate, on such great information shared. Questions are coming through. Let's see. How do I communicate with my clients about who I have identified as my surrogate attorney? Do I need to do this?
I'll take this one. In reviewing the rules, I haven't seen any states requiring that you actually notify your clients, but I think it is a nice customer service consideration, if you will. As I mentioned during the course of the seminar, I think the fee agreement is probably the most effective means advising your clients who your surrogate is so they have that contact information. But of course, making sure your staff, someone at your office, it has that information so if necessary, they can provide it to your clients.
Perfect. Thank you. How do I determine how much tail coverage I need when closing my practice?
Yeah, I can jump in on this one since I know I kind of quickly ran through that. But this is something you're going to need to discuss with your insurance agent and your carrier. The period for which the reporting period is extended, it's going to depend on your firm's needs and the circumstances. So the length of time the reporting period is extended, it's also going to affect the cost of your ERE. So that's something that will also help determine your decision. But I just want to make the point that it's an important consideration to think about the applicable discovery periods and statute of limitations for malpractice claims in your jurisdiction. That's something you definitely want to keep in mind when you're talking about how much tail you're going to need and closing your practice. So the best advice is contact your malpractice insurer and discuss your tail coverage options, and do this prior to closing your law firm, obviously.
Let's see. Is it okay not to renew my license or annual registration when I retire? Does having an active status mean I can no longer practice law?
I can jump in on this one, Kate. Yes. In fact, part of submitting your notice for retirement includes updating your annual registration and the status in the attorney information system. Inactive status will usually require you to still pay your bar fees to maintain your license, but you must activate your license to practice law. So both the retired and inactive statuses, they can be changed back to active if you meet the requirements that are set by your state bar, but inactive is typically easier to change, so definitely keep that in mind. If you think that you may practice again in the future, you can change your status to inactive, but you're going to need to change it back to active before practicing again. And rulings on this procedure, they are going to differ from state to state. And I feel like Kate and I keep saying that, but that's just really something important to think about. So check the rules in your jurisdiction.
Let's see, one more question here. Can my legal assistant respond directly to client emails when I'm on vacation?
I can start with that one, Erin. Erin provided some great information about how to unplug when you're on vacation, but typically we have to maintain some level of contact with the office. So while you can have your legal assistant monitor your inbox and perhaps forward pleadings or just some information that isn't substantive legal advice, of course we have to be wary of a non-lawyer providing legal advice. They can do that. But you want to have some system in place where if your legal assistant understands that your client is seeking, legal advice, that they can't provide that, maybe they flag that when they forward it to you, warranting a response directly from the attorney.
Great. And Kate, I would say you hit the nail on the head with your answer, but I would also just add to it by saying, I would advise that you inform your client that your assistant's going to be checking your emails, but then sending you anything that's really urgent, because this actually will give them more of a comfort level with you being away. And we talked earlier about tempering client expectations for any absence from the office, vacation, surgery, whatever you have going on. This is really important. So I would advise them, if your assistant is going to be checking your emails, I'd let the client know that.
On behalf of Attorney Protective, I would like to thank you all for joining us for today's webinar. Special thanks for Erin and Kate and such great advice shared. Thank you so much and have a wonderful day.